Hello and kia ora from Aotearoa, New Zealand to everyone there at Dutch Design Week in Eindhoven and virtually around the world. I'm Jack Yan, I'm co-chair of Medinge Group. Now, we're going to have a little talk today about the Whanganui River, and I want to give a quick introduction about that. Before the arrival of the Europeans, in fact the first one was from your country in the Netherlands, Abel Tasman, the people of a collection of Māori tribes, the Whanganui iwi, the tribes, cared for the Whanganui River as their te awa tupua, the sacred river. However, after the colonists arrived, the tribes' rights were extinguished and the river exploited, even diverted, which was considered a major affront to the Māori. After many years of protest, and more recently of work and negotiation by the iwi tribes and the Crown through the Office of Treaty Settlements, on March 20th, 2017, the Whanganui River was recognised in law as a living being, as the iwi had claimed all along. The legislation declared that the river is a living whole and has all the rights, powers, duties and liabilities of a legal person. One of the people who worked on the negotiation, representing the Crown through the Office of Treaty Settlements, is my partner, Amanda Satterthwaite. This topic came up at Medinge Group when we were discussing Native people's rights and how Indigenous people safeguard our biodiversity. And my colleagues had no idea that Amanda had worked on this. This is when we hatched the idea to get her to come and tell us a little bit about her first-hand knowledge of the Whanganui River. I'll introduce her in a second, and we're going to launch into the Q&As. Now, kia ora, Amanda, welcome.
Thank you.
Now, since our audience is in the Netherlands, can you quickly tell us about the purpose of the Office of Treaty Settlements and what you did there?
Sure. So I worked at the Office of Treaty Settlements for about 3.5 years, from 2012 till 2015. The purpose of the Office of Treaty Settlements is to act on behalf of the Crown, the Government of New Zealand, and negotiate treaty settlements with Māori tribes or iwi. And I worked as a senior analyst, and I worked on 2 main settlements, and one was with a Auckland iwi, Te Aki Tai Waihua, and the other was with the Whanganui iwi, and that was in regard to the Whanganui River.
So can you tell us a bit about the Treaty of Waitangi?
Sure. So the Treaty of Waitangi was signed between the British Crown and the Māori iwi in 1840. It basically gave the British Crown rights of sovereignty across the country, and in exchange for that, the Māori people got the same rights and privileges as British people had at that time. So they were kind of more or less treated as equal subjects. And very importantly, the treaty also guaranteed the Māori people across the country rights and access to their taonga or treasures, and that needed to be protected by the British Crown.
Now, it didn't always happen that way, did it? I mean, the breaches pretty much started happening right off the bat.
That's right, yeah. Pretty much as soon as the treaty was signed, in many small ways and then larger ways, the British Crown started to breach the various principles within the Treaty of Waitangi.
So Amanda, I know you've written down quite a few things with regard to the Whanganui River, where the Crown has been breaching its obligations. So going through your notes, can you just tell us what those breaches were?
Sure. I will need to look at my notes because there are quite a lot.
Quite a few things. It's a long list, isn't it?
So basically the Crown removed possession and control of the river from the hands of the iwi through various acts and through legislation. The Crown started to extract gravel from the river, which destroyed the traditional fishing sites of the iwi. Then the river was cleared and altered for steamboats. Then the mouth of the river became a drain for the city's effluent, which is not great.
No.
And then soon after the headwaters of the river, which is the head of the river, which is actually very sacred to Māori, that was actually the waters were diverted to go into a catchment for a hydroelectric power scheme. So a lot of detrimental things have happened to the river since the Crown started to enact this legislation and take this action.
Yeah. So the iwi, they started fighting back, eh?
They pretty much started fighting back as soon as the Crown started taking these actions, and they went to the court over the many years, and it was only until very recently that things started to go more positively for them. So they've been fighting for a very, very long time.
Yeah. So what was the original reason for giving the Whanganui River its own legal status as a person? Can you maybe explain the concepts first?
Yeah, sure. So it's really important to understand two important concepts. And the first one is Te Awa Tupua, and that's the name that the Whanganui River iwi call the river, Te Awa Tupua. And that essentially encompasses, it means all of the river. So the water, the river within the mountains, the river within the river, the river beds, the tributaries, the catchment area, the banks, and the metaphysical and spiritual elements of the river as well, that comes within the term Te Awa Tupua. So they don't just talk about the river in terms of a river that you might see on a map. They're talking about the river as a kind of physical and spiritual whole. So that's important to understand. And the other important element to understand is the tribal proverb Ko'o Te Awa, Ko Te Awa Ko'o, which means I am the river and the river is me. So that's all about how the iwi just have this just intrinsically, this deep connection to the river. So those two elements are important to understand and why the iwi chose to progress with this idea of the river being a legal person.
Right, I see. So how did that translate into the legislation?
Yeah, so going into the negotiations, the Whanganui iwi's key position was that the river should be legally recognised as a living whole, Te Awa Tupua, and that the iwi have an inseparable connection to that river. So those two key elements. And so this is what the final settlement legislation actually did. So on the 20th of March 2017, the New Zealand Parliament passed the Te Awa Tupua Whanganui River Claim Settlement Act. And so the Act basically declared what the iwi position was, that the river is a living being. The Act declared that Te Awa Tupua is an indivisible living whole comprising the river with all its physical and metaphysical elements, and henceforth possesses all the rights, powers, duties and liabilities of a legal person.
And we were actually there, weren't we? We were there when that got passed into law.
Yeah, we were.
we actually attended Parliament on the day with a lot of the Whanganui River iwi and associated iwi as the Minister of, what was it, the Minister of Treaty Settlements, is that his title? Chris Finlayson read it out. And it was really moving because they all sang. Yeah,
the iwi sang. Once the legislation had been read out, the iwi stood up and sang a waiata, and the members of Parliament also stood up as well and listened to that. So it was very, very moving because the iwi had fought for so long to have the river recognised as a whole kind of spiritual being, and now they had this translated, this recognised in legislation. And so they had Te Awa Tupua recognised, but they also, the legislation also enabled Te Awa Tupua to have the rights of a legal person. So that's pretty important. So those two key elements, they actually,
they came into play. Because I mean, this, I remember how moving it was, because we had people descended from the tribes who first took the crown to court in the 19th century, and here we're in the 21st century finally. So the relief you felt from some of the tribal members was like, great granddad took the government to court over this. Finally, I'm here in Parliament living, and I'm seeing this finally happen. And I think the other great thing was I had speeches from, obviously, Mr. Finlayson, who was in government at that point, but also from the opposition, from the Greens, from the Māori Party. It was unanimous among all the parties, which I thought was amazing.
Definitely, we've definitely evolved in our understanding of Māori philosophy and spiritual thinking within New Zealand. It's taken us quite a few years, but we've definitely got there, and it's really good to see that we're actually having this confirmed in legislation, which is actually quite amazing.
Cool.
Yeah.
Okay, so by declaring Te Awa Tupua a legal person, what gets achieved here?
Quite a number of things get achieved. First of all, basically the legal framework aligns with the Māori view of seeing the river as a living being and an ancestor, so that really nicely fits with that the legal status as a legal person. Also, the legal status provides for the river's long-term protection and restoration. Giving the river legal personhood means that the river has legal rights and can go to court, enter into contracts, it can hold property in its name. So basically it means that if somebody abuses it or harms it, in law it is a legal person, so it can do something about that in the courts.
Yeah, and this is quite similar really to a company having the status of a legal person in law, because that's a concept Westerners are familiar with. So this is bringing it into really what Māori believe.
Yeah, that's exactly right. It pretty much aligning the two concepts, or the kind of belief system with the legal status, and it changes the traditional approach to water resource management, which assumes that water resources should be managed primarily for people. It kind of upends that, and now it's all about the actual the river itself as a living being, and it having rights within itself.
Yeah. So the reality is, I mean, I think a lot of people out there will be thinking, does this mean that nature can sue humans for the damage they inflict? Does this actually have any teeth in a court of law?
Well, that's something that we don't know yet, because there have been no cases that have been brought on this matter, so we can only speculate. But for example, there is a hydro plant nearby which draws water from the Whanganui River, and that licence will be up for renewal in a few years' time, and so at that point then the legal status of the river as a legal person, I would think that the river itself would have a lot more say in whether that resource consent or that licence will be relicensed. So it'll have a lot more power.
And what about flooding? I mean, say hypothetically, the river floods the nearby town.
Yeah.
Can the township sue the river for flood damage?
That's right. As a legal person, you can be sued, and just like you can sue and you can be sued. So we don't know yet, whether that's going to be possible. I would think not, but it hasn't been, as far as I'm aware, it hasn't been brought to court to really understand what the limits are on that.
Okay. Okay, so has the settlement had a wider local or international impact on how we protect the environment?
Yes, it definitely has, but actually before the settlement was finalised for Whanganui River, there was another treaty settlement negotiation between the Crown and the iwi Tūhoi, and there's a national park called Te Irawera, and that was given legal personhood as well, legal personhood status as well. And there's also a mountain in New Zealand called Mount Taranaki, and that is set to receive legal personhood status. So that's at least three landmarks in New Zealand that will receive legal personhood status. And also, when I did some research online, I found that the River Ganges has been given legal personhood status by a high court in India. Those are the landmarks that I'm aware of that have been given this type of status.
So can future generations be optimistic about this move?
Yeah, I think definitely future generations can. The legal personhood status recognises the community's intrinsic connection to the natural resource and their desire for guardianship of it. So that's really important. It gives the natural place legal rights. With the legal personhood, they can the natural place can actually protect itself in the court of law, which is incredibly powerful. And it's really important in a time where there's so much pressure on natural places, natural resources. It's really important because other types of protections haven't really worked. And organisations haven't really worked, and so this is, I think, a pretty powerful way of giving those natural places, empowering them themselves as living things. I think there's definitely cause for optimism in this approach.
And future generations will be happy that we took this step to do it.
Definitely. I think so.
Well, I think that's on a very, very positive note. So thank you, Amanda. Kia ora. Thank you for presenting and telling us about your work at the Office of Treaty Settlements and on the Whanganui River settlement. So
no problem.
Tēnā rā atu koe. Thank you.